Welcome everybody to a very unusual DEFCON. Lots of things are different. Lots of things are staying the same, including, as always, the open organization of Lockpickers, Lockpick Village. We're so glad you're here. We hope that you can learn some things, have some fun, walk out more fired up about hacking and lockpicking than you arrived. My particular part of this today is Law School for Lockpickers. What even is that? Well, by way of background, I'm Preston Thomas, a former board member of TOOOL. I'm a licensed attorney barred in the District of Columbia and in California, which is importantly different than barred from DC and California. I've done this talk before, including at DEFCON, but 2020 has brought this topic into a new light. Security research of all kinds, from hacking, reverse engineering, social engineering, lockpicking, these all rely on civil liberties of an open society with rule of law. Hacking is by nature subversive. Lockpicking is no different. So, like journalists and priests and security researchers, our job is to comfort the afflicted and afflict the comfortable. We can do things many people don't understand. For certain types of people, encountering something they don't understand makes them nervous, irrational, maybe even angry. I should know, I've worked with TOOOL for almost 10 years and been a lawyer for longer. And when people get nervous, irrational, or angry about lockpicking topics, it often ends up on my plate. Falls to me to explain it. I've had this particular conversation hundreds of times. So this talk today, it isn't for you, it's for me. I want to recruit all of you into my crusade to push back on the tide of bullshit about laws and lockpicking and how the two interact. I'm tired. I want to be done talking about this, but people won't let me. Help me, please. Let's do this. To begin with, I am a lawyer. I am not, however, your lawyer. This is so not legal advice. The only advice I'm going to give you today is don't get your legal advice from a guy at a con. Also, my opinions are my own. They don't represent TOOOL or anyone I work for. Standard disclaimer. Law and Order was a great show because half was the cops and half was the lawyers. For the law part, you can just Google what the laws are in a specific jurisdiction or how to talk to a law enforcement officer. There's great stuff on YouTube about that. This is not that talk. This talk is more the second part, the order part, about why lockpicking laws are the way they are and what it means for you as a practitioner dealing with lots of non-practitioners. Everyone has legal theories about lots of parts of daily life, not just lockpicking. Most of them are workable, some of them are nonsensical, some of them are absolutely bananas. And where do loopy legal theories tend to come from? Armchair lawyers. Armchair lawyers everywhere with their good old University of Wikipedia law degree. And their specialty area is something I like to call folk law. These are these ideas about law that everyone seems to know, but no one really seems to know where they came from. This is, I want my one phone call, or if you ask someone if they're a cop, they have to tell you, or I don't have to pay income taxes because I live in the free state of Jefferson. Because of folk law and all the people opining about it and spouting off about it, Googling about lockpicking laws on the internet is worse than Googling about that weird rash. So let's get real. Today, let's do this law school style. We're going to be concrete, specific, and clear in how we use words. Let's start off this law school for lockpickers by building a law. Let's build a criminal statute called the possession of burglary tools, because that's almost always what we're talking about when we're talking about the legality of lockpicks. Criminal laws are constructed of elements. These elements are what need to be proven beyond a reasonable doubt before someone can be legally found guilty of a crime. In the case of a burglary tool statute, there's usually two elements. Possession is physically having a tool or device, including lockpicks, and intent means criminal mindset, i.e., you intend to do something that is against the law. You can call this formula possession plus intent. Now, intent is difficult to get at. It's in your head. It's not something the court has access to. So typically in a court of law, it's shown through circumstances. In other words, part of the district attorney's job is to show circumstances that make it beyond a reasonable doubt that a person had crime in mind at the time they possessed lockpicks. No circumstances, no intent, no crime. In most states, it's as simple as that. mere possession of lockpicks without any circumstances indicating unlawful intent, not a crime. You look across, you can see that is the vast majority of states. We color them green just because it's nice, it's soothing, it sends the right message across. But what about those shadowy places, you say, in your best Jonathan Taylor Thomas 1994 Simba voice? Remember how I said intent was really hard to get at? The court can't know what's in someone's mind. So who better to provide evidence about the state of someone's mind than the person themselves? That is the thinking behind that minority of states that just throw up their hands and say, you tell me. I'm looking at you, Virginia, Ohio, Mississippi, Nevada. Laws change over time, but they pretty much solidified down to these four as having the possession plus intent formulation. So these states, they write their burglary tools so that possession of lockpicks is prima facie evidence of intent to commit a crime. We'll talk about prima facie here in a second. Here's an example from the Code of Virginia. For those of you who like to follow along, this Criminal Code 18.2-94, the possession of such burglarious tools, implements, or outfit by any persons other than a licensed dealer shall be prima facie evidence of an intent to commit burglary, robbery, or larceny. So let's talk about that prima facie word. It's not law school without some Latin. Let's dive into it. Prima facie, Latin literally means on first face, or on first impression, you can think of it. In plain English, that means if I didn't know better, I'd say something. I'd say you're up to no good. Turning that back into legal language, that's referred to as a rebuttable presumption. It's a presumption because it starts off set to true, default value true. It's rebuttable because that default value can be changed, which means the ball is in your court. Or in more colloquial terms, prima facie means splaining. And I put this GIF up there, and I'm increasingly surprised how few people know what it's from. If you don't recognize this GIF, congratulations on your high school graduation, I guess. Okay, so people will often say, but I have a presumption of innocence, but my Constitution, I've got rights. And you're right, you do have rights, at least for the time being. But the presumption of innocence is not one of the rights that's guaranteed in the Constitution. You can read it, it's not that long. You should read it, it's worth the read. And one of the things you'll notice, there's no presumption of innocence mentioned in the Constitution. It flows indirectly from the 5th, 6th, and 14th Amendments. Coffin versus United States is one of the first cases you study in law school. And that shows how, even though it's not actually in the text, it was discovered as a necessary implication of the rights guaranteed explicitly in the 5th, 6th, and 14th Amendments. More importantly, though, this formulation of burglary law just won't be challenged in court because it's too much of an edge case to ever make it to trial. There's two things DAs hate. They hate crime and they hate losing cases. And because this formulation, even if it is arguably unconstitutional or might be, it'll never get tested, because if it's such an edge case that you might be able to make a constitutional argument, the DA will shrug his hands and throw it out. He doesn't want to go down that route. That's not what his job is. He's got much bigger fish to fry. So these kinds of problems where the law is a little unclear and common sense doesn't seem to quite match up with the way the law is written, that's why humans are in the loop. There's district attorneys with prosecutorial discretion. There's judges sitting over each trial. They're specifically there to handle exceptions where the law as written doesn't quite match up with the facts on the ground. So even if you might be able to have a constitutional problem with this formulation, know that it will probably never come to trial because no one's going to care enough about a fact pattern like that to actually push it. Now, there's kind of a sense of boo, hiss about these states that have possession implies intent formulation. And a lot of people think, oh, they're just wrong, or they're nonsensical, or they're anti-hacker, anti-lockpicker. But if you look at actually what their thinking is, it begins to make a little bit more sense and you have more sympathy for them. So I decided, let's look at some of them. First of all, I didn't know what the Nevada flag looked like. I had to look that up just for this presentation. Here's what Nevada decided. is they said in a case 1965 that is still good law, they said it is consistent with all the constitutional protections of accused men to throw on them the burden of proving facts, particularly within their knowledge and hidden from discovery by the government. This is an illustrative example of the kind of reasoning that motivates possession implies intent states. You don't have to agree with it, but you can see what their thinking is. If we're having trial and the goal of the trial is to find out what the truth is and whether someone is guilty, and that person has the information they say is relevant to the case, they should be able to provide it. If they have it, then the least they could do is show it to the court. It kind of makes sense. It's very simple. Maybe it makes some of our civil liberties impulses a little squeamish, but it's not unreasonable, especially when you consider the one we collectively like a little bit better, which is the possession plus intent formulation, the more liberal version. So why shouldn't we imply intent? And here's an example from the District of Columbia that shows the kind of reasoning involved in arriving at the idea that possession plus intent should be the proper formulation. And what they say is, and this is great close parsing by the judge. He says, although the sledgehammer, axe, and hacksaw, which the appellant had, quite clearly can be used criminally, they also may, and for the most part are, used for legitimate purposes. Since the mere fact of possession of such implements has no relevance to guilt, it may not be made the occasion of casting on the defendant the obligation of exculpation. In other words, unless what you're carrying are literally drugs or something else that's similarly illegal just for existing, then the cops have to introduce additional facts to overcome the statistical likelihood that you intend to use them for a legal purpose. Most people carrying axes, sledgehammers, hacks, hammers, etc., are using for legal purposes. So why, in this case, would we infer that they're using it for anything other than legal purpose? When you walk through it like that, it's kind of tortured logic. You have to suddenly appreciate the people who say, hey, you know what? It's probably what it looks like unless you tell us otherwise. I have a lot, after doing the research for this, I have a lot more sympathy for the jurisdictions that decide to throw up their hand and say, you tell us. I know some of you in the back are saying, hey, aren't there different types of intent under the law? Yes, but that's not relevant here. Any intent will do for this particular formulation. Now, this kind of close parsing and close analysis of the way laws are written and what's the meaning behind them leads to some really funny outcomes, including my favorite lockpicking case. It turns out I have a favorite lockpicking case. We are once again back in the District of Columbia. This is a DC appeals court, still relatively recently from 2014. In re JW means it was a minor involved. So some kid under 18 got nicked by the cops. Funny circumstances. Here's what happened. JW was arrested red-handed trying to steal a Vespa with a pair of bolt cutters. He was charged with possession of implements of a crime, which is the usual statute that applies to lockpicking. Both elements are satisfied, no question. He's sitting there, middle of the night, by the Vespa, bolt cutters in hand, definition of caught red-handed. Absolutely possession, absolutely intent. However, there's an inartful drafting of the statute because the statute specified, doesn't usually specify, but in this case it does, it specified tools for picking locks. A meticulous appeals court judge observed that picking a lock is generally understood to require skill rather than brute force, and to turn the lock without damage to the lock. He literally went and looked up the definition of picking a lock in the dictionary and came back with that and entered it in the record. As a result of reading the statute across from the definitions, it was, the judge concluded, not physically possible to pick a lock with bolt cutters, nor is it legally possible to convict JW under the statute as written, because try as you might, those big old bolt cutters will not fit into the lock and turn it in a non-damaging fashion. Conclusion, no possession of tools designed for picking locks, and JW goes free, and anyone who complains about that gets to go back and write the statute a little bit more carefully. I think that is a great example of a judge carefully parsing the statute, holding the state to what they said they wanted, and then telling them if you want something different, you have to be a little bit more careful. Another thing I like about this is this means that we have it on record that all those savages and reprobates at conferences who destroy the locks and tie the lockpicks into pretzels are not, legally speaking, picking locks. So here's the part that I think a lot of people show up for. The number one absolute main area of shouting and nonsense regarding locks and lockpicking is speculation on breaking the link between possession and intent. So let's talk about it. This is in those states where possession implies intent, those minority of states. Well, what can we do to protect ourselves? There's a thought that these are the places where lockpicks are illegal and we have to be on our guard and we have to have an answer ready. So what do we do about it? And something that often comes up is have a card, have some kind of self-made card or a more professional card. Poof, problem solved. This is that fantasy of holding it up to the officer and say, "Don't worry, officer, I have a permit for this." That couldn't be further from the truth. There is no such thing as a get out of jail free card, because they're absolutely allowed to have that conversation with you. And by the time you're having that conversation, it is not in your interest to try to avoid that conversation. Instead, I want you to think of, if you're having a conversation about lockpicks with a cop, it is in your interest to engage in and expand in and own that conversation rather than trying to flash some kind of card and avoid it. The TOOOL membership card, which is forthcoming, contains a few carefully crafted paragraphs to help you achieve a productive tone in that conversation. Essentially, act as a conversation starter. It's a way to help you have the conversation effectively rather than avoid the conversation. It explains that TOOOL is an organization that exists, that recreational locksport is a thing that exists, that the holder of the card is a member of TOOOL, and it gives a gloss on the general state of overall laws. It doesn't overplay its hand. It basically digs down to the idea that what we teach and what we do at TOOOL is legal everywhere in the United States by definition, because lock sporters and researchers have a legitimate use for their picks, and they follow the two rules, which are quite famously in TOOOL: don't pick a lock that you don't own, don't pick a lock upon which you rely. If you're following those rules, then you don't fall afoul of either formulation of the state law, no matter where you are. So that helps set the right tone. If you're a conscientious locksport practitioner, don't hide them, don't lie about why you have them. Essentially, don't act guilty if you aren't guilty. People will sometimes come to me and say, "Preston, that's all well and good, but what if I'm doing this or that or the other thing? What about this circumstance?" And what I always tell them is, if what you're doing is a crime, then you're literally doing what the crime of possession of burglary tools says, and you have no basis to complain. If, on the other hand, you're not, and you're practicing good lock sport ethics and you're following TOOOL's rules, then you can be safe in knowing that what you are doing is legal in every state in the union, and you have a card to help explain that concept to anyone who's asking. Now, we are very serious about keeping our members and our friends on the right side of the law. Nonetheless, and I want to emphasize, this is not legal advice. This is just wisdom that any person in a society should know. Let me give you a rule of thumb. Call it the one crime at a time rule. If you choose to break the law, don't break the law while you're breaking the law. Don't accidentally turn a legitimate hobby into an indictable offense by carrying lockpicks along on a time when you shouldn't have them. In the words of legal philosopher William Smith, in the matter of Earth versus Giant Bug, 1997, don't start nothing, won't be nothing. I have heard from many police officers, many different jurisdictions. I've asked them, I have been on public transit sitting there picking on my practice locks, and I've said, "Hey guys, I'm sitting here picking locks. I'm pretty sure that's acceptable. Do you have any problem with it?" And they say, "Planning on picking locks on the train? Are you planning on picking locks on the airplane?" They don't care. They have actual crimes to worry about. If you're sitting there as a law-abiding citizen doing something that's not bothering anybody, it's not worth their time. So don't be nervous about it, and don't worry about ignorance of the law becoming a problem for you because you're willing to have that conversation. Another area that people oftentimes ask about is federal law, particularly TSA. DEFCON is one of the most common sources of that question, because people say, well, I just bought lockpicks, but now I can't take them on an airplane. Well, it's not a factor, because it is literally, I've lost a T somewhere, I've got to fix that. But it is literally not a factor, because TSA has a set of things that they're looking for and a set of things that are not on their list. Because a lockpicking tool is a non-sharp tool, less than 7 inches, it's carry-on approved. It's simply not disallowed, which means it's allowed. And don't say this to TSA if you're having that conversation, but the locks on the cockpit doors are not even pin tumbler locks. So all the more reason for it not to be on their list. After years and years of asking them, we've got Twitter conversations from a bunch of different people here. Their agents finally added lockpicks explicitly to their can I bring my self-service site on the website. So if this is a concern for you and you would like a little extra backup, then feel free, go on the website, take a screenshot, print it out, throw it in your lockpick kit. I've done it. I know a lot of friends of mine in TOOOL have done it. We carried around our lockpick kit for years and years and years until it got ratty and torn up. Then we threw it away and we never used it. Once again, because TSA agents just don't care. But remember, like anything that you want to carry on a plane, the TSA agent gets the last call. So be polite, be friendly, be patient with them. Whether you're doing an opt-out or bringing something unusual through carry-on, just make sure you have enough time to have the discussion without being rushed or being flustered. Yes, I like opting out. There's good ethical reasons to it, even though sometimes it's a pain in the butt. If I'm in a hurry, I don't want to miss my flight, yeah, I'll go through the scanner. Carrying lockpicks is likewise. If I'm really in a hurry, I'll just check them. But for the most part, I like carrying them on, A, because I know where they are, because they're valuable, and make sure they don't get broken, but also to make sure that I'm practicing what I preach and telling people, yes, it's not a problem. And on the rare occasion I have those conversations, then I can make it that much easier for the next person coming behind me that's bringing lockpicks. One of the best pieces of advice I get when I got in law school, when you're having conversations like this, is always try to seem like the most reasonable person in the room. Seem like the most reasonable person in the room. If you seem like you're prepared for the conversation, if it's not a surprise for you, then that really helps them be that much more calm about it. As a last resort, many airports will give you the option to mail something home rather than trashing it. Another great option if you've got time to take advantage of it. Here's what I do when I'm taking my lockpicks through an airport. This is my bin on the inside of security at San Francisco. Note the gigantic bag of lockpicks, including the fuzzy handcuffs right on top, just in case anyone wants to get curious. That's all totally legal, as are the Bogotas in my wallet, which is there on the right. No one ever notices that. Ironically, the illegal thing in the picture is that little bottle of Kraken rum there. I totally did not know that you were not allowed to bring the little bottles through security or onto the airplane. You're not allowed to provide your own booze. So yes, there is something illegal going on in that picture. No, it's not the lockpicks. Yes, it is the booze. A note on having fun with TSA. I like putting the handcuffs on top because if they're going to open up the bag, I like to put a smile on their face. It gives them the problem of, do they dig around the handcuffs? Are they allowed to pick the handcuffs up? This is, a dildo versus your dildo territory. As long as they're going to have the conversation, there's no reason we can't make it a little bit fun. And before you ask, yes, handcuffs are also legal, are also permitted in carry-on. Lots of good reasons for that, including security officers and police officers that always travel with handcuffs. A few years ago, Lady Gaga brought her own fuzzy handcuffs, and there was a bit of a hullabaloo about it, but they were, of course, allowed on. So fun lockpick tricks. Just carry fuzzy handcuffs as well. It helps set the conversation on the right mode. A comment that I got from Max, who works with TOOOL, he said, always remember that you can help the conversation along by giving some framing. So if you see your bag of lockpicks go through the x-ray and the person's eyes kind of light up and they shunt it off to the side for further inspection, wave at the guy as you're walking over. Start off the conversation just right. I see you've got my bag of lockpicking equipment there. I do this, that, or the other thing. I do lock sport as a hobby. Inside, you will find the following things. You can help them get in the right frame, and there's kind of an art to helping them arrive at their own conclusions rather than dictating to them, and which in a way that might make them suspicious. So don't avoid the conversation. Welcome the chance to practice the conversation. It's almost always no big deal because, again, it's a non-sharp tool, less than 7 inches. And we will pass handcuffs and we will go to the rest of the world. And people often ask me now that I've talked about the United States, well, what about the rest of the world? And the answer is the rest of the world does not differ materially from the United States for the most part. Everywhere around the world, you'll find countries and individual jurisdictions with both formulations. The most common formulation is possession plus intent, but there are some places that have possession implies intent. So Commonwealth, UK, Australia, New Zealand, Canada, they're all legal. Some of them are possession plus intent. Some of them are possession implies intent, but none of them make it strictly illegal. Netherlands, as we know, TOOOL having started in the Netherlands, perfectly legal, and there's quite a robust culture there. Israel, a little bit more tightened down. They're definitely in the possession implies intent camp. And I'm given to understand that in China, they're fairly illegal, but like many things in China, it depends on who your patron is. So yes, when TOOOL goes to China, we do take lockpicks with us. We teach lockpicking there, and we get it all cleared through the proper authorities, and we haven't had a problem yet. Now, there's one last thing that needs to be said before I round this out, which is 2020 is in some ways different than other years. In some ways, no different than it ever was. We're just learning more about it now. The Black Lives Matter movement has really drawn a lot more attention to the interaction between young Black people, people of color, and law enforcement. And it wouldn't be right to finish this talk without mentioning that all the advice I gave works great if you are a white, reasonably well-educated male lawyer. Does it work as well if you're not some of those things? And the only answer I can tell you is all the principles remain the same, but it is absolutely hard mode. It's no surprise that you might have to speak better, understand better, make yourself heard better to get the same results. And there's nothing that I can say to make that okay in this talk or to really give a lot of insight from a perspective other than mine. But I do want to acknowledge that the law is the same and many of the same principles apply, but it's hard mode. So that is the laws of lockpicking. I understand as we end this, I'll have a chance to take questions. So for anyone who has questions about lockpicking in the US, around the world, who has stories they want to tell, who has hypotheticals that they want to get insight on, I would be happy to share them. Mostly, thank you for showing up for this conversation. Happy lockpicking. Look forward to seeing you around.
Okay, everyone. So we've got Preston here with us, ready to answer some questions. So this is your chance to get in there. Okay, everyone. So we've got Preston. So first off, we've got a couple of people saying thank you for the talk and doing a great job there.
Thanks for coming. Always nice to share that. As usual, this talk is as much for me as it is for you guys because this is a conversation that I, as a lawyer in lockpicking, have all the time. So thank you for helping with this mission that is an ongoing one, but it's been getting better over time.
Yeah, so just remember, if you are on the Discord, put your questions in LPV general text. If you are not, for some reason, there are chat functions that we can monitor on both Twitch and YouTube, so just pop your questions in there, and I will read them off to Preston.
And I'll have to say, as some people are typing, I kind of miss the annual ritual of taking all the lockpicks through the airport on the way to and back from DEFCON. It's always a fun chance for me to brush up on my conversation skills of talking to people with badges and guns. And it's always a good reminder for them that these are the laws and this is what to expect, particularly at DEFCON. If they're going to have a problem with lockpicks, they're going to have a bad day. Just less so this year. Let's see, we've got a question from Ox Overflow here. Have you ever had any officer curious to learn more about lockpicking and wanting to get into the hobby? Yes, I absolutely have. The cops tend to be gearheads just like anyone else, so they've got their everyday carry. They've got opinions on guns. They've got opinions on cars. And a lot of cops tend to have, at the very least, a Slim Jim, right? So they know that. I've had conversations, at least one conversation with the DC Metro Police, where I was sitting there on the Metro with my lockpicks, just sort of practicing, but ostentatiously practicing, so that like out in plain sight. And that started a lot of good conversations, including with some of the transit police, and they didn't seem to care. One of them thought it was cool. Actually, a woman behind me, an old African American lady, not only commented on what I was doing, but told me I was doing a bad job at it. And back in her day, she could open the types of locks I was working on much more quickly. So I didn't doubt her at all. But that's the kind of thing you get in DC area.
Okay. Any other questions? So Ariel comments, I really like the respectful entry stuff that I've seen from some firefighters in EMT, such as Coastal Fire.
I'm going to have to check that out. By respectful entry, I wonder if that is meaning if they're doing a welfare check or something, they can do it without breaking the door in. That makes a lot of sense. It's an additional tool. I have not actually heard specifically of cases of that happening, but that totally makes sense. Yep, here's the link right here. I highly recommend that link.
Yeah, there's some interesting stuff there where it's they're trying to balance the need to gain entry with trying to be minimally destructive about things. Like, yes, it's an emergency, so you have to get in quick, but also you don't necessarily need to rip the entire wall out.
And pointing out that this is statistically speaking more likely to happen in low income areas where they're having more contact with the police. Being able to take that extra couple of seconds and be good enough that you can do a non-destructive entry is a nice way to help maintain and repair relations, like especially when you're showing up there with the goal of helping someone, serving, protecting, making sure that everything is okay. It's not a good look to break down the door as a way of helping someone. So yeah, underscores the fact that lockpicking and law enforcement are definitely well aligned. There doesn't need to be any. They're not intrinsically enemies. In fact, a lot of law enforcement personnel tend to be gearheads. They like locks. It's locks and glocks. Anyone who's sort of a preparedness kind of person has an affinity for those. So no, I think it's a nice way to have that conversation of this is a tool that professionals need to know or at least have an understanding of. And law enforcement is professionals like anyone else.
Okay, so we'll give people a couple more minutes to put in any questions they might have. At the end of this Q&A will be the end of our broadcast day. And then shortly after that, around the end of the hour, we will be closing the Lockpick Village for the day.
Awesome. Well, as people begin to filter out, I just want to say one more time, take this conversation out into the world. You guys are here because you are hackers. You're here because you're lockpickers. You care about this kind of thing. You care about the perception. So help me have that conversation with people that no, lockpicks are not illegal. It is much more nuanced of a conversation. It's not that they're legal. It's not that they're illegal. It's that facts matter and conversations matter and tone matters. And that should be something that anyone who participates in lockpicking is capable of doing, is having that conversation in a respectful way that someone walks away thinking, not only I've learned something about the law of lockpicking, but I've also met a lockpicker who was a nice person, was a cool dude, was a gal that I feel like I can trust. And that does as much to move the needle as any specific piece of case law or legislation.
So we'll give people just another minute or two, but while we're waiting for any stragglers there, you say there's been any major updates or things that you've thought of since you originally came up with this last year?
I have to say, on account of 2020, not a lot has changed in the lockpicking world. Things have changed wildly elsewhere. But I was a little startled by how topical the Black Lives Matter comment at the end of the presentation was. That continues to be true, and I think that's going to be true for the foreseeable future. In the lockpicking end of it, the main thing I would say is that lock sport as a hobby continues to grow wildly. It is it has doubled in size in 5 years, and before that, it doubled in size before that. So the exposure that people have to lock sport is way more than it used to be, and I think that can only do good because that means people are more likely to know about it, know someone who does it, have a good impression of it, rather than just having heard about it from media sources or from scare stories. We've got a comment from Ox Overflow here. The TOOOL member card that caught their attention. Is that something new coming for next year? And the answer, I'm sorry to say, is that it is perpetually new coming next year. It's been an ongoing project that the board has taken a couple of different runs at. I'm no longer on the board, so I can't say exactly what the process is, but there have been demos people have had in their hands, actual working versions. By working versions, I mean official TOOOL versions that looked pretty good. It is something that members have asked for. Members are entitled to them, and some individual members have gotten them, but I think those are only on a test one-off basis. So yes, the main thing I would say is if you want your membership card, you're not alone. Bug your chapter leader and have your chapter leader bug the board, because that's how we set our priorities, is what the members want based on what the chapter wants, and the board members have a job, and their job is to be responsive to what the members want. So yes, there are plans in place. Much of the heavy lifting has been done, but there are still other issues, which I don't know what those are.
Since I am on the board, I can offer a little bit more in the way of details, which is the last set of hurdles that we ran into, aside from the pandemic kind of putting an end to a lot of our in-person collaboration. was primarily issues with printing and distribution logistics. So moving less from the design and into, well, wait, now we have to print a few hundred or a few thousand individualized cards and figure out how to distribute each personalized card to the correct person.
Yeah, and it's worth pointing out that there's a lot of questions of, well, what personal information do we put on the card? It has more value the more closely it is identified with your government name and face, but a lot of people in TOOOL tend not to want that. There's some fun to it, or they have a real or imagined allergy to it. So the TOOOL board has been very ginger in going about developing this document and getting it printed and collecting the information. So yeah, it's not as simple as just getting a card reader and a card printer and running off a bunch of them, but we are working through that.
Yeah. So I think that's about it. I don't see anyone else furiously typing away, trying to get in under the wire. So, speak of the devil. Okay.
Awesome, then.
Thank you.
Thank you, everyone. Always a pleasure.
And with that, thank you very much, Preston, for taking the time to be here and answer questions for the audience. Thank you, everyone, for spending your time at the Lockpick Village today and watching our talks. And we will see you all tomorrow morning. Thank you very much.
Good night.